Good morning. Thank you so much for joining us this morning for our webinar on the Social Security disability process. Before we go any further, I do want to state, as always, that this webinar is not intended to be legal advice, but is instead meant to serve as additional education surrounding the Social Security disability process. I also want to say, as always, I try not to answer a whole lot of questions, if any, on the live webinar. And the reason for that is because I often need additional supporting information to give a solid answer. And I cannot always do that in a webinar format where you are kind of providing your personal information in a non-private setting. And then I also don't respond to a lot of questions in the comments on the replay for the same reason. If you do have specific questions, I do encourage you to reach out to us. We will go ahead and drop a link in the chat on the live webinar now. If you know you've got questions that you want to try to schedule a call to address, we will also put that link in the chat again at the end. If you're watching on the replay, that link is down below in the comments. And the last page of the webinar slide deck will also show our phone number, email address, and website. If you do have questions, those are alternative ways to reach out to us. So as I always say, I'm always happy to help in any way that I can. I just unfortunately can't really answer a lot of questions on the webinar or the replays because in order to give good advice, when possible, I do need additional information. Without further ado, this is our roadmap for today. We are first going to do an introduction, talk about Social Security disability basics, and then there are two Social Security processes that we are going to talk about. The first one is the Social Security disability case process, which is what happens from initial application through the conclusion of your case. And then the second process is the process that the Social Security Administration uses when they are evaluating your claim for disability benefits. And then finally, we are going to talk about the Beacon Disability Application Assistance Program, which is open right now. And we will talk about what that is and what benefits you may be able to get if you are able to join that program. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability, PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, helping clients with their Social Security disability insurance and supplemental security income, which are SSDI and SSI cases, at the agency level. So we do help from the initial application through the appeals counsel stage. If for some reason we cannot help you, we do try to put you in touch with somebody who may be able to help. So as I stated before, please do feel free to reach out if you have any questions, and we will try to help if we can, and if not, try to connect you with somebody who may be able to. Okay, Social Security disability basics. As I alluded to, there are two different Social Security disability programs. There's Social Security Disability Insurance, or SSDI benefits, and there's Supplemental Security Income, or SSI benefits. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months due to mental and/or physical impairments. If you, the other option is if you have been diagnosed with a condition that is expected to end in death within that 12-month period. Where the programs differ is with SSDI benefits, they are going to require that you have a sufficient number of work credits. We typically say that that means that you must have worked 5 of the last 10 years. And with SSI, instead of the work credit requirement, you've got to have below a certain threshold of income and assets. So the asset threshold for SSI is you cannot have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married. Okay, so that is the two, those are the programs. The other thing to mention is with the 12-month duration requirement. You do not have to be disabled for 12 months before applying. If you've watched a webinar before, you've joined us before, you know that I typically recommend as soon as you realize that you're going to be disabled and unable to work for a year, apply. Even though that year hasn't passed yet, if your doctors are telling you it's unlikely that you'll go back to work in a year between the injury, the recuperation, potential surgeries, potential therapies after, whatever it is, if they're anticipating that you're going to be unable to work for a year, go ahead and apply. What sometimes will happen is Social Security will say that, we're going to hold on to your claim because we're not sure what's going to happen. They may also just go ahead and deny it and think that you're going to get better. And in that case, then you would go ahead and file an appeal as long as you're still disabled and unable to work. Here is the process of a Social Security disability case. Starts out with the initial application stage. If it gets approved, that's great. It stops there. If the initial application is denied, especially for a medical reason, where they say that you're not disabled according to our rules, or they will say that we believe you can adjust to other work, which is also that you're not disabled according to their rules, then you can file a reconsideration appeal. And that is where they will request everything again. They look at it. If they approve your reconsideration, then that's great. Your case stops there. If they deny it, you remain disabled and unable to work, you can file a request for an administrative law judge hearing. At the hearing stage, if you get approved, case stops there. If you get denied, but you still believe you're disabled and unable to work and that the judge made some errors of fact and or of law, then you can go ahead and file an appeals council appeal. The appeals council, if they can do a couple things. They can refuse to review it, and we'll talk about this in detail in a minute. So I will leave it at that. They can do a couple things. You can, if you get denied at the appeals council, file an appeal in federal court. And then that sometimes starts some of the process over again. We don't talk a whole lot about the federal court, but it is part of the Social Security disability case process. So I wanted to make sure to include it. Okay. At the initial application stage is a lot of getting information from your brain over to Social Security. This month, the last couple of weeks, we've done specific webinars on the SSDI and SSI applications. If you have not watched those, I recommend you go back and watch those. They are available for replay right now. Watch that. You'll see what kind of background information they need. You'll see what kind of information they'll need about your conditions, your doctors, hospitals, clinics, imaging centers, psychologists, therapists, all of that, and as well as your work history. So the initial application is an opportunity for you to share all of that information with Social Security. They do need that information to properly process your claim. And once you get all of that information over to them, they will look to first make sure you meet the secondary prong, which is either that you have enough work credits under SSDI to qualify for that program, or if you're applying for SSI, then they're going to make sure that your income and assets are below the required thresholds. So I did mention before the asset threshold for SSI, $2,000 in assets if you're single, $3,000 in assets if you are married. There's also income restrictions. If you have no income, of course, that's not an issue. If there is income coming into the house, for example, if you are married and or you have children, there are income thresholds as well. They are also bright line rules, but because there's so many different possibilities, I don't cover those in detail. You can find those by going directly to the Social Security Administration's website and looking up like SSI resources, SSI income information, things like that. And you'll be able to see what the income thresholds are. At the initial application stage, once you submit your application, once the agency confirms that you do in fact qualify, either you have enough credits under SSDI and or you are below the income and asset thresholds for SSI, they then look to your medical information. They're going to look at the conditions. They're going to look at your doctors. They're going to request the records from your doctors. So they then review those records, and we'll get into this a little bit in the second portion where we talk about the SSA process, but they're going to look at all of that and they determine whether or not you are disabled under their rules. If you are disabled under their rules, then they will go ahead and you'll get an approval letter, you'll get a notice of award that will outline all of your benefits. If they deny it, but you and your doctors believe that you are disabled and unable to work, you can file a reconsideration appeal. The reconsideration appeals must be filed within 60 days of the date of the initial denial, plus an additional 5 days for mailing. So we like to keep it as close to the application denial as possible, because then it kind of keeps your case moving along. But you do have up to essentially 65 days from the date of the denial to file that initial appeal. You can appeal online. If you have an attorney hired already, they will work with you. You'll want to make sure that they did receive the initial denial, and you'll want to make sure you provide them with an update, because Social Security will then pull updated records. So if your medical treatment is ongoing, which it should be, you want to make sure that you tell your attorney and or Social Security directly about all of the ongoing medical treatment that you have to ensure that Social Security will have a complete file to review and make their reconsideration decision on. At the reconsideration decision, again, Social Security will request all of the records, they review it, and they send out another decision. If they approve it at reconsideration, great, you're done. You've been approved. You'll get your approval letter. You'll get your notice of award. I don't know why I'm tripping over my words today. And you'll shortly thereafter start receiving the lump sum benefits, if any, as well as the monthly benefits. If they deny the reconsideration appeal, but you believe you're still disabled and unable to work, you can file a request for an administrative law judge hearing. Again, 60 days plus an additional 5 days for mailing. The time between when you file your request for hearing and when it's actually scheduled varies widely. It really varies within the same state and really throughout the country. We've got some pockets of the country that we're seeing cases scheduled within a few months, which is kind of a 6-month minimum. We're seeing other pockets of the country where it's taking much longer than that. So it really just depends. The time between that request and the hearing date does vary. If you are represented, if you have a lawyer with you at the hearing level, make sure you keep in touch with them and communicate with them about your ongoing medical treatment. As soon as you start seeing a new doctor, let your lawyer know, because what will happen is when you get your hearing scheduled, your lawyer will need to know, okay, who have you been seeing? And they'll need to make sure that all of your medical records are updated. They work with you to make sure that all of those records are updated and into Social Security. So instead of having to remember the last, let's say, year of medical treatment and who you've gone to, new providers, this, that, and the other, it's much easier if you just make sure you're providing that information proactively to your lawyer as it's happening. That can be very helpful. If you are unrepresented, communicate with Social Security about the medical treatment. And what happens often is Social Security will send out form letters. They send it if you're represented as well. They send out form letters asking about those updated medical sources. And that is so if you are unrepresented, that Social Security can try to get those updated records. So what I recommend is to just keep a list, even if you don't want to bother your lawyer every time you get a new provider. That's not bothering. But if you don't want to reach out to your lawyer every time, that's fine, as long as you're keeping a list somewhere. So that way, when your lawyer or Social Security reaches out and says, hey, we need to know all the providers you've seen over the last 6 months, you can easily provide that information. When you get to the hearing is an opportunity for you to speak with a Social Security Administration judge about your condition and how it impacts your ability to function on a daily basis. So sometimes, I've got clients that think that the hearing is my time to talk, my time to shine. It is in some ways, and I do prepare my case and myself for the hearing, but it's also about preparing you for the hearing. The hearing is not my time to shine, it is yours. You are the only person, short of your family and potentially friends that live with you, who know what you go through on a daily basis. And even your family and potentially friends that live with you, they're not in your body. They don't know what you're dealing with. They don't know the ins and outs of everything that's going on. They can understand, they can empathize, they can really see a lot more than I can, and certainly more than the judge can. But you know best. And so it's really an opportunity for you to explain all of the limitations that you have as a result of your condition. It's important when you're testifying and making these explanations that you are not overstating the limitations and not understating them and sugarcoating the limitations. We want to make sure that everything is being as open and honest and accurate as possible, because what happens is your limitations that you're testifying about get compared to the medical records. And so you want to make sure it all jives together, all matches together. But that's the main purpose of the hearing, is to give you an opportunity to explain to somebody where you have their undivided attention for 30 to 45 minutes, so they can try to understand. They've got the medical records, but what does all of that actually mean for your day-to-day activities? If the ALJ denies your application for benefits, of course, if they approve it, then it's the same as the other levels. You'll get the approval letter, you'll get a notice of award, and then your monthly benefits will begin shortly thereafter. If they deny it, you can file an appeals council appeal. You can request appeals council review. The appeals council is based in Falls Church, Virginia. It's not a second hearing, but it's another file review. And what they're looking at is, did the administrative law judge make errors of fact or of law that, had they not made those errors, could have resulted in a favorable decision? So they're not rehashing everything. They're not it's not a second opportunity, a second bite at the apple, but it's instead they're now looking at it kind of at a different lens, which is, did the judge make errors? So it's a little bit tougher. Once you've got I always tell people, once you've got an unfavorable judge's decision, you've got to contend with that pretty much for the rest of, forever. So it can take anywhere from a few months to a year or longer at the appeals council. It depends on their caseload. Typically, new and updated evidence is not going to be the main focus. It can be accepted. It depends on your case, your situation. But by and large, like I said, they're looking to see, did the judge make errors that, had the judge not made those errors, could have resulted in a favorable decision. So it's a different threshold. And finally, as I mentioned, if the appeals council also denies the claim, you can file a claim in federal court. It's a civil suit. It's the last level of the appeals process. It's filed in the district court of the United States for the judicial district in which you live. And the appeals council does outline how to appeal their denial and how to file in federal court. I do typically recommend, if you're going to go this route, that you do have a lawyer. There are costs involved, filing fees, things like that. So I do recommend that if you do go that route, that you have a lawyer that handles those cases. Right now, we do not handle these cases, but there are lawyers throughout the country that do. As long as they are admitted in that district court that you need to file in, they may be able to help and provide guidance. Here's the second process, the Social Security process of determining disability. So we just went through kind of the process from approval, or from application to potential approval, or the last stop on the appeals ladder. This is the process that happens when you file an application for Social Security benefits. As I mentioned before, the very first thing they're going to look at for SSDI is, do you have the work credits? And the very first thing they're going to look at for SSI is, are you below the income and asset thresholds? As long as you get through that hurdle with whichever application you filed, or both, then they move on to this step. And they're first going to look at, are you engaging in substantial gainful activity? Then they go to severe impairments. Then they look at the listings. Then they look at your past relevant work. And then they look at other work. And you will see in a minute what all of that actually means. Step 1, are you engaging in substantial gainful activity? Right now, they're going to look at, if you are working 20 hours a week or more, or earning more than $1,470 a month in gross earnings, you are considered engaging in substantial gainful activity, and by their definition, cannot be found disabled. So that's what they're looking at here, is, are you currently working? Are you engaging in substantial gainful activity? If you are, you cannot be found disabled by their rules. And so they'll deny it at step 1. They'll say, you're engaging in substantial gainful activity. You cannot be found disabled according to our rules. Now, step 0, which are the making sure you have a sufficient number of work credits and below the income and asset thresholds, and step 1 denials are not typically denials that we help with. We typically help with step 2 and beyond. You can tell what type of denial you get sometimes by how quick it comes back. If it comes back right away, then that's usually a step 0 denial. That's usually going to be a letter where they say, nope, we can't, you don't have enough work credits, or nope, you have too much income, too many assets. So step 0 denials, if it's wrong, you can still appeal. If it's correct, unfortunately, there's not much you can do about it, because those are the rules. Step 1, if you are engaging in substantial gainful activity, which means that you're working 20 hours a week or more, or earning more than $1,470 a month in gross earnings, again, if you are doing that, then there's no real way to appeal. You are doing that. That's what Social Security says, and therefore you cannot be found disabled under their rules. If they say that you're doing that and you're not, it's kind of hard to prove a negative, but that's what you've got to do, that you are not working or engaging in substantial gainful activity. As long as you're not, you qualify at step 0, you're not engaging in substantial gainful activity, then they move to step 2, where they start looking at your medical records and they evaluate your impairments. They are looking to see, do you have one or more severe medically determinable impairments? And that means that you have to have a severe impairment according to the medical records. And a severe impairment is one that is going to have an impact on your ability to perform work-related activities like standing, sitting, walking, lifting, pushing, pulling, crouching, kneeling, stooping, crawling, your ability to focus, your ability to interact with others, your ability to follow instructions, your ability to attend work, things like that is what's going to be looked at here. And as long as you have one or more severe medically determinable impairments, they'll move to step 3. If you don't have at least one severe impairment, then they deny your claim at step 2. They say, nope, you don't have any severe impairments. You can do whatever job you want to do. Step 3, as long as you have one severe medically determinable impairment, they look to the listings. And they look to see, is your condition listing level? Does it rise to the criteria included in the Blue Book of Listings? If you've ever looked at the Blue Book of Listings, you know that the criteria are pretty strict. So if you do meet or equal a listing through your medical records, that's wonderful. At this step, they'll go ahead and approve your benefits. You get the approval letter, you get the notice of award, your benefits should start shortly thereafter. If you don't meet or equal one of the listings in the Blue Book, what will happen is Social Security will assess your case and they will assign an RFC, or a residual functional capacity, to your case, which is what they think you're capable of doing based on the medical records. And taking that RFC, they will look, can you perform your past relevant work? So as I mentioned before, and if you've watched the previous webinars, you know that past relevant work is work performed in the last 15 years that you have performed long enough to learn how to do the job. So it's not every job, but if you've performed the job long enough to know how to do it and it's been performed in the last 15 years, that is going to be past relevant work. If you had a job as a nurse for a month, that is likely not going to be past relevant work. You probably did not perform that job long enough to learn how to do it. But if you were a nurse for the last 15 years, that's going to be your past relevant work. They use that RFC. They look to see, okay, can somebody with this RFC go back to do your past work, either as performed or as per the Dictionary of Occupational Titles? If you can go back to your past work with your RFC, they'll deny your claim. They'll say you can go back to doing your work. If you cannot go back to your past work with your RFC, what they'll then do is they will go to step 5, and they will look to see, can an individual with your age, education, work experience, and RFC adjust to any other work that exists in the national economy? So keeping with the nurse example, if you were a nurse in the OR and you cannot go back to that past work because now you've got sedentary restrictions, you're limited to sedentary work, but you were a nurse in the OR for 15 years. A lot of times what will happen is Social Security will say, you can go back to doing other work that's less strenuous, okay? Nurses in the OR is a pretty demanding job, but there may be a job like a school nurse that is not as physically demanding that you may be able to do because you have those skills that you learned previously. So that's one example. That's an example that I have seen happen before. And that's why, again, if you've watched my webinars, you know that I don't pick on nurses, but I pick that out as a career often because there are a lot of, nursing is a mentally and physically taxing job. And so a lot of times, we do deal with a lot of, unfortunately, nurses who are older and no longer able to do what they have loved doing their whole career. And they kind of get hung up on this stage a lot of times. And there are ways around it, but that's what step 5 is. At step 5, if you cannot adjust to other work based on your age, education, RFC, and past work experience, then you would get an approval. Okay, if there's no other work that you can do, then you can get an approval at step 5. You get the favorable decision, you get the notice of award, and your monthly benefits start shortly thereafter. If you can adjust to other work, then that's where you still get a denial at step 5. So that is the 5-step evaluation process that Social Security uses to evaluate applications, reconsideration appeals, and cases at the ALJ level. Okay. Appeals council, a little bit different. Federal court, also a little bit different. So these 5 steps are used from initial to administrative law judge. Once you've got that administrative law judge decision, the analysis changes a little bit. We're not going to spend time on that today, but just to know that. As I mentioned, we do have an application assistance program where if you are eligible to join the program, you can we do help with the initial application, as it says, but there are additional benefits that you can get, such as access to the webinar replays, exclusive videos regarding the application and the application process, the appeals process, We've got a video bank that discusses different aspects of the disability process. And we also give access to your own client portal where you can log in, you can ask questions directly of us, you can upload documents directly to us. The portal we found is just a really wonderful way for you to receive ongoing support and assistance through the application and potential appeals process. As I did mention, we do help with filing the initial SSDI application directly with Social Security. And for more information about the application assistance program and to see if you might qualify, you can go to that website. And what we'll do here is we will go ahead and drop that website into the chat. I think you can just click it that way. And we will also drop a link to schedule a call. With the application assistance program, what will happen is it'll take you to a landing page and you'll be able to see there what kind of some of the criteria are. You submit that information, we take a look at it. And at that point, then we'll usually go ahead and send you an email and schedule a time to chat to get more information from you about that to see if you qualify. Again, here's our phone number, our email address, and that website. If you have questions connected to the application assistance program, connected to applying for disability, appealing disability, please do feel free to reach out to us. We do like to help in any situation that we can. Thank you so much for joining us today. Have a wonderful day.